Welcome to the second half of our very long webinar that started last week. We want to welcome those of you back who were able to join us for the ERISA and employee benefits portion of our webinar hosted by Lexology. My name is David Hall. I'm the Chief Marketing Officer here at Hall Benefits Law. And today I'd like to introduce you to Employment of Counsel Jennifer Harris, who is going to be sharing with each of you a bit about shifts in the employment law landscape, important action items for you, legislation that may be coming down the pike, and legislation that has already been passed that is already impacting employers. So with that, Jennifer, I'll let you jump in.
All right, thanks so much, David. I appreciate you guys letting me come into your lives. I'm sorry that I couldn't be with you on the actual webinar day, and I appreciate being able to catch up with you now. So I did want to just talk through some of the employment law changes that we're looking at, as David mentioned. I want to back up just for a second to the ARPA. I know that Ann Tyler talked about this probably a decent amount on the day of the actual webinar. But I did want to point out a couple of other things. Another important provision of ARPA was the extension of federal unemployment insurance benefits yet again. ARPA extended 3 different types of COVID-related unemployment benefits through September 6th of this year. And also added an important tax benefit for employees receiving unemployment benefits. Specifically, under ARPA, it exempts the first $10,200 of unemployment benefits from federal income taxes, as long as those benefits were received in 2020, and as long as the household AGI is less than $150,000. For taxpayers who filed prior to the ARPA's enactment, they may need to amend their tax return. And in Georgia, for those of you in Georgia, I know this is a more national audience, the Georgia DOL announced on March 19th that it's implementing these additional benefits as well. So those are a couple of things that I wanted to cover back on ARPA, and now I'm going to move into the employment realm. So obviously, I know this has been, as David mentioned, a long webinar. There's a whole lot to discuss, and we've covered a lot already. And there's so much more to cover in the employment section. I'm going to start with the WARN Act because I think it's really a relevant piece of legislation. And I'll go through it fairly high level. It may not seem high level when we're in it, but I'm not going to go through all of the definitions verbatim. I provided more details on the slides, which I understand that you've gotten, and that will provide a reference point for you if you find yourself staring down a WARN situation. So what is WARN? You've probably all heard of it and likely experienced it firsthand, particularly since the pandemic hit. And while I'm optimistic that the worst of the rifts have passed us, it's worth revisiting. WARN is a federal statute passed in 1988 with the intent of helping communities prepare for large-scale employment losses that could occur within it. Simply put, under the federal WARN Act, covered employers are required to give 60 days advance written notice of an upcoming plant closure or mass layoff, as those terms are defined in the statute, to certain affected employees. It sounds pretty easy in one sentence, yes, but unfortunately it's not. As written, the federal WARN statute is very technical, can be hard to follow, and is anything but intuitive. So what makes it so tricky? The statute and its implementing regulations are convoluted, and the definitions used for some of the most basic terms that flow throughout the statute, are not intuitive. For example, to determine if an employer is covered by WARN to begin with, and then also if notice is required in a given situation, you need to determine how many employees were employed by the employer at a given time, generally the day that notice should have been given if it was required. And then also for employment loss purposes. For the employer coverage calculation, there are 2 options provided, and for both, you exclude part-time employees. And you also exclude part-time employees in determining plant closure and mass layoff thresholds. What's interesting here and what makes it unique is that part-time employees are defined uniquely under the statute to not only include employees who worked part-time in the traditional sense, fewer than 20 hours per week, but also newly hired employees. So those employees that have been employed fewer than 6 of the 12 preceding months, as of the date notice would be required, not your traditional definition of a part-time employee. Other pain points within WARN, while the employer coverage component is fairly straightforward, except for the part-time thing, You also have to determine whether your proposed course of action, your reduction in force, is a covered plant closing or mass layoff, as those terms are defined. And because the statute was originally written to assist communities, the threshold numbers for those are not based on the employer as a whole, but based as to a single site of employment, or an SSE, excuse me. Not surprisingly, a single site of employment can refer to a single location, but it also can refer to a group of contiguous locations, such as within a campus or an industrial park, separate facilities across the street from each other, or even separate buildings or areas not directly connected or in immediate proximity. Those may be considered a single site of employment if they are in reasonable geographic proximity, used for the same purpose, share the same staff and equipment. The regs and case law provide some additional guidance on these points, but it's really a case-by-case analysis, depending on the employer setup and the proposed reduction in force. And once you have your single site of employment, you can begin to determine if the threshold losses will be met, excluding part-time workers. So then it seems easy enough. You just look at your proposed layoffs and determine if you meet the threshold numbers, 50 or more at a single site of employment for a plant closing. Same for a mass layoff if it's at least 33% of the employees at that site, or 500 employees. Well, yeah, that's true, but the statute doesn't just take each RIF on its own, which is another complicating factor. Rather, the Act instructs employers to aggregate its actual and planned actions by looking at either a 30-day or a 90-day period of time, depending on their circumstances. We'll get back to that and talk about that more in a couple of slides. So also important in the calculation is counting those employees who will experience an employment loss, as that's defined in the regulations. Specifically, except as otherwise provided in the regulations, employment loss means an employment termination other than a discharge for cause, voluntary departure, or retirement, a layoff exceeding 6 months, or a reduction in hours of work of more than 50% during each month of any 6-month period. The exclusions reference relate to closures related to the sale of all or part of the employer's business, as well as employees who are offered a transfer to a different position within the company in lieu of termination and or with a limited period of unemployment. So really what I'm trying to point out here is there's a whole lot of moving pieces with WARN. Many of this is less than clear cut. All get to the decision of whether notice is required, and if so, when and to whom. So you've determined that notice should be required. When and whom should it be given? I briefly touched on this a few slides ago, but this is another WARN pain point: the aggregation of employment losses to determine if the notice requirement is triggered. WARN, through its regulations, instructs an employer on how to determine if notice is required when all employee terminations are not scheduled for the same day, which is a common occurrence. In that case, you use the snapshot approach outlined here, which involves either a 30-day look back and forward or a 90-day look back and forward. I have dissected this to the nines many times, and all I can come up with is this. If you aren't terminating 50 people at one sitting, you should look the full 90 days back and forward. The snapshot should be based on the number of employees employed as of the date notice should have been given, or 60 days prior to the beginning of the plant closure or mass layoff. Once you do all that, you know whether you're required to give notice and when. Depending on the circumstances, there may be mitigating factors that lessen the amount of notice required, sometimes even such that you can provide notice after the fact. Some of these have come into play with COVID, but to date, I'm not aware of any blanket rule holding that COVID is per se an unforeseeable business circumstance or a natural disaster such that notice is always reduced. And except for potentially the natural disaster exception, these do not excuse notice entirely. They might just make delayed notice acceptable. You're still always required to give as much notice as practicable. Given the time it takes a case to go through the court system, we don't have a whole lot of case law guidance on these exceptions as applied to pandemic-related RIFs. In one recent Florida case out of the Middle District of Florida, the district court in the Middle District declined to dismiss WARN Act claims based on the defendant's assertion of both the unforeseeable business circumstances and the natural disaster exception. That was, of course, at the motion to dismiss stage. In that case, the court found that, as to the natural disaster exception, the pandemic could qualify as a natural disaster, but the complaint had not alleged that the employment actions taken were a direct result of a natural disaster, as is required in the pleading requirements. The court was less decisive in rejecting the unforeseeable business circumstances defense. In doing so, excuse me, still a little bit sick. It noted that this exception often softens the notice requirement, but does not eliminate it entirely. The court ultimately concluded that nothing in the complaint or the attached documents showed that the defendants couldn't have given more notice as required by statute. The court added, exactly when defendants had to give notice will doubtless be a hotly contested factual issue. But at this stage, the motion to dismiss stage, taking the allegations in the complaint as true, plaintiff has stated a claim under Warren. This case is now at the 11th Circuit for consideration, so it's one that we need to watch, and I'm sure other opinions will be coming out that will help in this as well. So if notice is required, who should receive it? Under Warren, affected employees, I think I went back one slide, sorry. Affected employees should receive notice. And affected employees are defined as those employees who may be reasonably expected to experience an employment loss, includes employees who will likely lose their jobs because of bumping rights or other factors, to the extent that such workers can be identified at the time notice is required to be given. If at the time notice is required to be given, the employer cannot identify the employee who may reasonably be expected to experience an employment loss, the employer must provide notice to the incumbent in that position. Important here is that while part-time employees are not counted in determining whether plant closure and mass layoff thresholds have been met, such workers are due notice. And probably the most straightforward of the whole statute is what notice should provide. There's slightly different requirements depending on the notice recipient. The name and address of the employment site where the plant closing or mat layoff will occur, and the name and telephone number of a company official to contact for further information. A statement as to whether the planned action is expected to be permanent or temporary, and if the entire plant is to be closed, a statement to that effect. The expected date of the first separation and the anticipated schedule for making separation. The job titles of positions to be affected, and the number of affected employees in each job classification, an indication as to whether or not bumping rights exist, and the name of each union representing affected employees, and the name and address of the chief elected officer of each union. The notice may include additional information useful to employees, such as a statement of whether planned action is expected to be temporary, and if so, its expected duration. So clear as mud? I know, if you're a little confused, trust me, you're not alone. When in doubt, err on the side of providing notice, as the regulations do appear to address that there is ambiguity and it's not clear, all that clear under the statute. So they do encourage employers to provide notice in all situations, even ambiguous ones, as noted here. What happens if employer fails to give adequate notice without an arguable exemption or exclusion? Damages and civil penalties can be assessed. This can include having to pay all employees the amount of pay and possibly benefits through the required notice period, which is up to 60 days and possibly more in some states. We'll discuss that at the end, but some states do have their own WARN provision that should be considered in addition to this federal WARN that we're going over now. Potentially also medical expenses incurred during the time benefits should have been available, as well as a civil fine of not more than $500 for each day of violation. If an employer can prove the act or omission was done in good faith and with a reasonable belief that no violation was being committed, that may reduce the employer's liability. That's up to the court's discretion. Back pay liability is reduced by any voluntary severance or extra vacation pay given to employees, unless the employer was already obligated to make those payments by law or by contract. And by their very nature, WARN claims are ripe for class action filings because you're dealing with multiple people. And as I mentioned before, don't forget mini WARN. That's the name given to state WARN counterparts. Many states have enacted these state level statutes that supplement the Federal WARN Act. It should be consulted as they may have differing obligations. These include states including California, no surprise, Hawaii, Illinois, Iowa, Maine, Massachusetts, New Hampshire, New Jersey, New York, Tennessee, and Wisconsin. At any rate, you should always check your state to see if there has been a mini warrant implemented, especially during COVID, as there have been some local and state rules that may supplement warn, but may not be specifically labeled a mini warn. So what else do we need to consider? Warrant is a big one to consider for larger scale risks, but it's certainly not the only consideration. All the normal employment concerns still apply as well. Title VII, of course, is a big one, as you know. Title VII prohibits discrimination against employees and applicants based on race, color, national origin, gender, sex, and other protected characteristics. And discrimination can be proven in several ways, including evidence of intentional discrimination, which actually isn't all that common, and evidence of disparate treatment of an employee and disparate impact, which is key here. With disparate impact, the focus is on the consequences of a facially neutral policy or action rather than the intent of the employer. The question there is whether the practice has or had a disproportionately adverse effect on one or more protected employee classifications. So in conducting a RIF, you want to do an adverse impact analysis early in the process and update it as moving parts move, as they tend to do with RIFs. If you find that your proposed actions adversely affect one or more protected groups, you may need to dig into different groups specifically and even different employment decisions to make sure you are able to articulate a legitimate non-discriminatory reason for the decisions that you've made. In addition, you'll need to make sure you've got your documents in compliance with applicable law, including any state law nuances. If you're offering severance through a company severance program or pursuant to employment agreement or collective bargaining agreement, or other benefits like paying out PTO or providing COBRA subsidy where not legally required, make sure you've covered your compliance basis. This includes, without limitation, ADA compliance, which with required timeframes for consideration and revocation, as well as adjusting for payouts, and Exhibit A details on decisional units. Non-waivable claims need to be properly set out. Make sure you've included language covering the Defense Trade Secret Acts where applicable. Confidentiality and confidential information need to be properly safeguarded. Injunctive relief should always be provided for in your agreements. Restrictive covenant agreements are either incorporated if pre-existing or included as new terms. Payout timing and possible Internal Revenue Code considerations are made. And then some state law requirements may also be at play. For example, under the Illinois Workplace Transparency Act, that requires 21 days to review and 7-day revocation period for all releases, regardless of age, not just as required under the ADEA. Other states have similar, so you should always consult your state law as well. As COVID continues to predominate, what are some other areas to be mindful of? COVID immunity statutes at play. Initially, COVID immunity statutes began popping up last year, primarily related to and focused on healthcare providers. Then they started to expand to include businesses more generally. While they vary state to state and each state statute should be viewed separately, there are some recurring trends among the statutes. Most provide immunity to covered entities from liability against COVID exposure claims in most circumstances. They do this most commonly in a couple of ways. First, the statutes generally include a heightened pleading standard for the complaining person. In order to file a case, they often have to include an affidavit from their attorney and or their healthcare provider and or plead the facts with specificity. The standard of proof is generally the higher, clear, and convincing evidence standard. And liability is also often limited to cases where the business or employee acted or employer acted with a higher degree of recklessness or through intentional conduct. Businesses and employers can generally cite to their adoption of CDC and or state practice, COVID practices on social distancing, sending employees home when they're sick and the like, to help establish the reasonableness or non-recklessness of their behavior. The real key here is in states where an immunity statute is play, audit your COVID practices to make sure you can take advantage of immunity if necessary. OSHA priorities are also a big one to be aware of. recently issued guidance in January of 2021 for non-healthcare workplaces, contain recommendations as well as descriptions of mandatory safety and health programs. The guidance called for employers to implement COVID-19 prevention programs within the workplace, noting that the most effective programs should engage workers and their unions or other representatives in program development to include the following key components: conducting a hazard assessment, identifying a combination of measures that limit the spread of COVID-19 in the workplace, adopting measures to help ensure that workers who are infected or potentially infected are separated and sent home from the workplace, and implementing protections from retaliation for workers who raise COVID-19 related concerns. The guidance provide additional detail on key measures for limiting the spread, starting with separating and sending home infected or potentially infected people from the workplace, implementing physical distancing, installing barriers where physical distancing cannot be maintained, and suppressing the spread by using face covering. It also provides guidance on the use of PPE when necessary, improving ventilation, providing supplies for good hygiene, and routine cleaning and disinfecting. In addition, Biden's executive order directed OSHA to consider whether emergency temporary standards on COVID-19 were necessary, and to issue them by March 15th of this year. Most expected they would issue something that mirrored their 2020 guidance, but making those provisions mandatory. And while we did not get anything by March 15th, on June 10th, OSHA did finally issue its ETS, but that ETS focuses exclusively on employers within the healthcare field, which was not expected. No big changes from the January guidance were really noted. As the name suggests, it is non-mandatory, which is what OSHA put out for non-healthcare employers. Rather, it provided recommended practices for employers and focused really on protecting non and partially vaccinated employees, as well as high-risk populations. Provides recommended practices for employers, and again, it's still not mandatory, but it should be reviewed. As case law develops defining after the fact the standard of care for employers as to COVID, these guidelines may be cited and used to assess how an employer acted, again, after the fact. So it's important to consider them in developing your COVID practices. Finally, in response to President Joe Biden's January 21st executive order on worker health and safety, OSHA launched a national emphasis program on March 12, 2021, with the stated goal of significantly reducing or eliminating worker exposure to COVID-19. This NEP is set to remain in effect for up to 1 year from its launch date, and it also included an added emphasis of OSHA anti-retaliation provisions. The NEP primarily focuses on business that OSHA believes put the largest number of workers at serious risk of contracting COVID-19. While the targeted establishment unsurprisingly includes those in the healthcare industry, also included are establishments which OSHA believes non-healthcare essential workers are likely to have the highest frequency of close contact exposure to the public or to coworkers resulting from their on-site work-related duties. Many establishments in the manufacturing industry, such as food and beverage manufacturing, chemical manufacturing, primary medical manufacturing, and transportation equipment manufacturing are included in the list. Also included are general warehouses and storage facilities and companies in the construction and energy sectors. The establishments included with the NEP will be targeted for programmed, i.e. random inspections. During these programmed inspections, OSHA will generally perform inspections on site and focus on evaluating compliance with standards related to record keeping and reporting of injuries and illnesses, respiratory protection, personal protective equipment or PPE, sanitation and access to exposure and medical records, and assessing whether any OSHA standards or the general duties clause were violated and whether a citation is warranted. OSHA stated that it will consider the latest CDC recommendations and guidelines. The NEP also calls for prioritizing COVID-19 related unprogrammed inspections, such as investigation of COVID-19 related fatalities, hospitalizations, complaints, referrals, and follow-up investigations. During the NEP's pendency, OSHA's goal is for at least 5% of inspections it conducts to be COVID-19 programmed and unprogrammed inspections. Although emphasis programs are generally not implemented until a 90-day outreach program is completed, OSHA stated that sufficient outreach has already been conducted during the duration of pandemic, such that the emphasis program was made effective immediately. State plan jurisdictions have 60 days to notify OSHA of their intent to adopt the NEP. So a third area that we want to be mindful of course, is vaccinations. And I know you've probably heard so much about this that you're blue in the face, but I just want to cover a few highlights of vaccinations because there is a lot to consider around them as more and more Americans become fully vaccinated, but we have to know that a strong minority remains opposed to the idea. EEOC and ADA considerations with vaccine. In general, the ADA permits employers to make disability-related inquiries and conduct medical examinations if job-related and consistent with business necessity. The EEOC has issued guidance covering the basics as to COVID. Due to the pandemic, employers may ask employees if they are experiencing symptoms of the pandemic virus. They may take temperatures, even though that is considered a medical examination. They may require people with symptoms to leave the workplace. They may require fitness for duty to return, but they have been urged to consider new approaches given the overload on the medical system. They may administer their own tests before allowing an employee to enter the workplace and or periodically check for the presence of COVID at their workplace, but they should not rely on antibody testing. Employers should do these things consistently, either for everyone or for anyone where there's a reasonable belief based on objective evidence that the person might have COVID. While an employer may ask if the employee has had contact with anyone diagnosed with COVID or having symptoms, they should not generally ask about family members and or their general health. A general question about all contacts will generally solicit COVID-specific information to include family members if relevant. In terms of a vaccination program, the ADA allows an employer to have a qualification that includes a requirement that an individual shall not pose a direct threat to the health and safety of individuals in the workplace. However, if a safety-based qualification standard, such as a vaccination requirement, screens out or tends to screen out an individual with a disability, the employer must show that the vaccinated employee would pose a direct threat due to a significant risk of substantial harm to the health and safety of the individual or others that cannot be eliminated or reasonably reduced by a reasonable accommodation. Under these circumstances, the EEOC has stated that an employer may refuse entry into the workplace for an employee who refuses to have his or her temperature taken or answer questions regarding symptoms and testing status. Questions related to travel are also allowed and would not generally be disability-related inquiries in other contexts. Employers do need to remember that all inquiries should be treated as confidential medical information and stored separately from the employer's personnel files. Staffing agencies may provide the name of the employee to the target employer due to the need to determine close contacts. For applicants, medical inquiries and examination are allowed only after a conditional offer of employment has been extended. In this context, undue hardship is defined as significant difficulty or expense. And one thing the EEOC has made clear is that accommodations are not required in order to avoid exposing a family member who is at higher risk of severe illness from COVID-19 due to an underlying medical condition. The guidance further explains that employers should conduct an individualized assessment of 4 factors to determine whether a direct threat exists. First, the duration of the risk. Second, the nature and severity of the potential harm. Third, the likelihood that the potential harm will occur. And 4, the imminence of potential harm. So taking these factors, if there is a conclusion that a direct threat exists, then the employer cannot exclude the employee from the workplace or take any other action unless there's no way to provide a reasonable accommodation absent undue hardship that would eliminate or reduce the risk so that the unvaccinated employee doesn't pose a direct threat. What about mandatory vaccination programs? Again, this is an area that I'm sure you've heard a lot about. The EEOC has issued guidance on the subject a few times, in fact. In general, an employer may be able to implement a mandatory vaccination program as long as there's a mechanism for handling objections based on medical concerns under the ADA as well as religious accommodations. And interestingly, a recent case pending in federal court in New Mexico involves an employee seeking an injunction to prevent him from being fired for refusing to get a COVID-19 vaccine as required by his employer. In that case, the employee did not assert a disability or a religious belief, but rather that the vaccines have only been approved by the FDA under emergency use guidance, or EUA, and therefore cannot be mandated. It will be very interesting to see how this case turns out. The vast majority of employers I have worked with have decided not to implement a mandatory program for a variety of reasons. But most are considering incentives to encourage employees to get the vaccines, including paid leave time for vaccination, which may actually be required in some states, like Nevada. On this topic, you need to keep an eye out as states may begin passing leave laws related to the vaccine. And as just mentioned, Nevada recently passed one. I believe it's in effect any day now. And in early March, the New York Senate passed a bill that would provide public employees in the state up to 4 hours of paid leave to get the vaccination. So outside of COVID, and we do have life outside of COVID, what are some of the other employment hot topics we're watching? Pay equity is a huge priority. The Biden administration has been transparent about its intent to focus on a few key areas, with pay equity being at the top of the list. We expect that this priority will be shared by incoming agency leaders who will be tasked with setting their agency's investigation and enforcement priorities in line with the Biden administration. In addition, several states already have pay equity laws on the books, some of which provide a safe harbor for companies to conduct a good faith, reasonable pay audit before any lawsuit is filed, and then make reasonable progress in eliminating prohibited wage disparities discovered. Massachusetts and Oregon, for example. And as more and more states like California and Colorado begin to require employers to annually report certain pay equity data, the need for employers to be ahead of that and know what their data to be reported looks like ahead of reporting is increasingly important. In addition to states, the EEOC is expected to return to collecting pay equity from large employers after that practice was halted under former President Trump's administration. Key to this process is maximizing the attorney-client privilege to the greatest extent possible. That can be done in a variety of ways, and engaging counsel early is key to that. Experienced counsel will work to safeguard the privilege in a variety of ways, including initiating and leading the audit, helping to ensure communications are appropriately marked and that thoughtfully chosen audit team members are appropriately trained against inadvertent waiver of the privilege, directly engaging third-party consultants if needed, and providing an attorney-prepared formal assessment. Engaging outside counsel early is particularly important, as there is case law that's held that using only in-house counsel may not preserve the privilege if that counsel also functions in a business capacity. Also, you can expect to see changes in the areas of employee classifications, particularly independent contractor and joint employer liability. While different, these are two legal theories that may have the potential effect of expanding liability for employers or entities. For joint employer, the issue is whether an entity who is not considered the traditional employer exercises such control and discretion that the entity should also be considered an employer of the employee, with all the responsibilities and potential liabilities of being an employer. And the flip side of that coin is the independent contractor determination. Oftentimes, entities will engage someone to provide services as an independent contractor, but that entity retains such discretion and control over the worker that they should properly be classifying them as an employee. So why is this important? Because the FLSA requirements regarding minimum wage, overtime, and record keeping apply to employees, but not independent contractors, misclassifying someone as an independent contractor when they should be an employee can have major consequences. So what's happening in these areas? It's been common for the rules and regulations relating to these two areas to shift somewhat based on the administration in place. With Republican administrations, the rules tend to become more employer-friendly. With Democratic administrations, the rules tend to become more employee-friendly. It's probably not a surprise that this is an area that may see some influx. In both cases, the Trump administration proposed rules and regulations that were seen as more employer-friendly. Within joint employer rules, those rules were put into place in January 2020, setting forth a 4-factor balancing test. While some of those regulations were invalidated by a New York district court, the Biden administration is proposing to rescind those rules. While it's unclear what they will propose in their place, we can assume that those would be in line with the Democratic administration, so more employee-friendly. Similarly, employer-friendly Independent contractor regulation updates were proposed by Trump in early January 2021, but they were quickly paused when Biden came into office. As of right now, implementation of those rules have been paused, and most expect that they will never go into effect. We also need to watch out for changes to union organization rules. For those of you that aren't currently unionized, why do you care? You may be asking. The NLRB exists to protect the rights of private sector employees under the NLRA to join together with or without a union to improve their wages and working conditions. This includes the right of employees to engage in concerted activity, which is 2 or more employees taking action for their mutual aid and protection regarding the terms and conditions of their employment. It also provides employees the right to attempt to form a union where none currently exist. And the NLRB may get involved if employees, formally unionized or not, take part in protected concerted activity, or if an employer creates conditions that may legally discourage that action or union organization. In addition to the NLRB, keep an eye out on the DOL. While it has much less power than the NLRB in this area, the confirmation of new Secretary Marty Walsh may bring some noteworthy changes. Most importantly, people are wondering if he will try to bring back the Obama-era Persuader rule. This was a 2016 proposed rule that would have required labor attorneys and certain other, quote, persuaders, unquote, to disclose when employers hired them for advice on avoiding unions. Obviously, this could have a huge chilling effect on union avoidance activity. It did fizzle under Trump after a Texas federal judge blocked it from taking effect, but many expect that it will attempt a comeback under this Democratic administration. Also in this area, the Federal PRO Act, which remains under consideration in the Senate, is very important to watch. The Protecting the Right to Organize Act, or the PRO Act, passed the House earlier this year and is now at the Senate for review. While it's unclear how quickly it might get through or if it will get through at all, it has had some momentum. So while it could all go away if not passed, if it is passed, it would be a major change for employers. And so it is high on the radar. In its present form, the act would make vast union-friendly changes to the NLRA and be the biggest change in labor law in decades. Some of the areas that it would change if enacted as currently presented would be extending joint employer liability, expanding the definition of employees by narrowing the definition of supervisors and independent contractors so that individuals previously not covered by the act would be covered or more easily covered, eliminating the right to certain work protections, allowing for picketing and strikes, more expansive picketing and strikes, eliminating employers' right to permanently replace economic strikers and prohibit offensive lockouts, mandate interest arbitration for the initial CBA negotiations, enhanced remedies and penalties, including potential civil liabilities for officers and directors in circumstances, and most importantly, numerous potential changes to union election rules, including codifying the NLRB 2015 quickie election rules, which allow union elections to take place within as little as 13 days from an election petition. This would be, again, a major change to the labor law landscape. And we could also expect possible shifts on certain employer policies, which may require you to revisit your handbook. Finally, not surprisingly, we're starting to see an increase in wage and hour litigation related to COVID, particularly as to screening time and whether it's compensable under the FLSA and or state wage and hour laws. The most recently noted surge has been seen in California, New Jersey, and Arizona, but we do expect this to continue and to expand throughout the United States. The issue here is where employers are having non-exempt employees do pre-employment screenings without compensation. This would include temperature screenings, completing daily assessments, and answering questions about their health, hand washing, and other cleaning and sanitation requirements. So this is a big area for employees to consider, as most employers have implemented some or all of these pre-screening obligations to the employees in line with CDC guidance. And David, that is all I have for you today. Thank you guys so much for listening to me talk for this extended amount of time. I do appreciate being able to be here, especially after the fact, and being allowed to make up for the missed actual webinar day. And if you have any questions on anything that I've covered, always happy to be here as a resource for you. Thanks again, and you guys be safe.
Thank you so much, Jennifer. We appreciate you taking the time out of your day after being sick to join us and to bring this incredible content to employers who need it. And we look forward to the next time.
All right. Thank you so much, David. I look forward to it as well.